let's look at the issue of discrimination as have been opined by so many commentators on the issue of the JAMB and the 16 years rule for admission into our universities.
Yes, that issue has generated a lot of controversies, and some have argued that those that are not matured should not be admitted to university by reason of their age, notwithstanding their special intelligence and brilliance and all that. But if you look at it, vis-a-vis the laws in this land, we have the Constitution of Nigeria, 1999, as amended. You have the Child Rights Act, you have the African Charter on the rights and welfare of the African child. You have the Covenant on National and the cultural and economic rights, and there's so many international legislations. Will you discover that the right to education is the basic right of the Nigerian child? The Child Rights Act says that much. The African Charter on the welfare and rights of the child equally says that much. But you see the jurisprudence of the right to education in Nigeria, particularly in Nigeria, has, been somehow dynamic. If you take a stroll down the memory lane, in 1994, there was a case of Badejo and the Minister of Education, where the applicant went to court to contend that he was denied his right to education. Unfortunately for him, the High Court dismissed his case, contending that the right to education was not enforceable. That case was taken to court under the 1979 Constitution, which has similar provisions with 1999 Constitution on the issue of justiciability of some rights in Chapter 2 of the Constitution. He appealed to the Court of Appeal, and equally his appeal was dismissed on grounds that it was not a justiciable right. That is to say that the right to education cannot be enforced in the court of law. However, the cheering news is this, that recently there are about 3 decisions that tend to confirm that the right to education is a fundamental right of the child and is enforceable in courts of law. One of them is the decision of the High Court of Lagos State by Justice A.M. Lawal in Adedoyin and JAMB. That was a case where the candidate was offered admission by Redeemer University. He scored very high in UTME and he has good work results, was offered admission. But JAMB refused to release his official admission letter. He went to court. And the judge, Justice A.M. Lawal, took time to look at the Constitution of Nigeria, the other laws, and came to the conclusion that as far as the Nigerian child is concerned, he has a right to education, and that right is a constitutional right. He also went on to say that he gave instances of some candidates that were exceptionally brilliant, that made landmarks in their academic journey. That if you have used age to stop them, to hinder their academic progress and advancement, that would be unfair. And that case.
All right, let's we'll come back to that case. Barrister Deji, of course, is there any justifiable law in which JAMB is hinging this restriction on students who wants to gain admission that's not up to the age of 16?
Well, thank you very much. As far as the law is concerned in the country, there is no statute that bar specifically that impose an age limit to the admission of students. It's just a mere convention that many universities have put forward that once you are below the age of 16, naturally you should not be regarded as somebody worthy to be given admission. There is no law that supports that position so far. It's even inconsistent with some of the development under international treaties that Nigeria have signed, some of which have been domesticated. Okay, we have the African Charter, for instance, and people's rights. We also have the Covenant for Socioeconomic Rights, which guarantees basic education and tertiary education for all Nigerian children. And also we have the Covenant of Political Rights, which also gives certain rights to education to Nigerian students or Nigerian youth or young people, as it were. And if you look at even our constitution, yes, my good brother have talked about the non-justiciability of the provisions of our fundamental right clause in our constitution as regards to education. But you find that the courts have always established that every child has also a right to freedom of thought, belief, conscience, and all of which had been interpreted in some decisions before now as including the right for education, the right to own information, the right to have information, and all of that. Sorry. But you also, yes.
Yeah, but Barrister Deji, some will argue that the restriction on age, does it abridge the right to education?
No, it does not. It does not.
It means that you are denying the person education.
Yes, it does not. That's the point I'm making, that if you look at the preponderance of legislations, even the preponderance of some of the development in international treaties, you will discover that the Nigerian Constitution even does not recognize discrimination. You know, you cannot discriminate against person by the circumstances of his birth or the situation relating to even his rights, fundamental right, the enjoyment of his fundamental rights. And to that extent, some of those laws are just some of those principles and policies are not just in place. They are inconsistent with the Constitution. Yeah, then you also find that, yes, I also want to mention this very important point before I forget, that you also find that the Child's Right Act is very, very fundamental on the right of children to have good education, whether at the elementary level or at the tertiary level, you know, and the right to equality and equal treatment of these students to gain education. Yeah. So to that extent, there is no law that supports that restriction that is being placed.
All right, Barrister Mike, so on the curiously, one want to know if a restriction on age equals to denial of rights to education, because the JAMB have not said that they won't get admission. JAMB is simply making a policy. Of course, I also want to know if they are not empowered to make policies that guide, you know, this admission process, if they have not been given the power by the Constitution to make policies.
Of course, the JAMB has the powers to make policies that are in consonance with the Constitution and other enabling laws. But you see, once there is any restriction on any child to have access to education, it's a denial of education. It's not an issue of saying that until you grow to a certain age, that is when you will be allowed to go to school. If you say that, it means that you have not allowed the child to exhibit his intelligence, exhibit the natural tendencies that God has embedded in the child.
But you are so, we have an educational model which
very well. If a child, you see, the educational model has not really said that.
Because the educational model, the implication of the educational model is that you need to get to a certain age before you could get admission. You're in a 633 educational model, where before you get into nursery school, you're supposed to be a certain age, then primary 6, secondary 3. So there is a calculation from that you ought to, except you have jumped those processes.
No. You don't need to jump. You see, if you even follow the processes, the ages they are talking about, by 15 you would have been able to go through all the processes, all the stages to be able to be qualified to enter the university. And several children have done this. It's not only exceptionally brilliant children. Several children, average Nigerian child has moved from the nursery through the secondary school before the age of 15.
Yeah, but are you also aware that even in nursery school, there are certain age you can be admitted into nursery school following the educational model?
That's what I'm saying.
So that is a policy. Will you say that is a discrimination also?
No. It's not an issue of saying that is discrimination or not. What I'm telling you now is that in the nursery school, you see, there is a stage that a child would not be able to disseminate, to be able to assimilate, or to be able to understand what is going on, what you are teaching him in the school. And so the laws allow that child to remain in the house of the parent until the child is able to maybe make science and able to communicate.
So is that not a discrimination?
So
if the parent
it's not discrimination. It's not discrimination.
Now the issue is this. Let's narrow it to what it actually is. Has JAMB
The constitutionality.
the authority
Yes.
to refuse admission to a candidate who has passed and is eligible to admission in tertiary institutions? My answer is yes. And that is going by what the courts have said. I've already mentioned the case of Adedoyin and JAMB. The other was Martins and JAMB, all in 2025. No, the other was December 2024, the other was this year. And JAMB then said, okay, they went back to drawing board. I said, okay, for students to come that are below about 15 or thereabouts to be allowed in a portal, they have to click that they understand they are underage, but they want to apply as sexually brilliant candidates. But see, the law is clear.
Now,
that if you look at the Constitution, if you look at the Child Rights Act, the African Charter on the rights and welfare of the child, which Nigeria domesticated, there's a right of the child to education, clearly encapsulated there. And that right includes right to accessible education,
affordable,
then that
access.
is accessible, that is also qualitative education, and then there are 4 elements of that right. It must be available. Availability is one. The education has to be available to the students. It must be
affordable.
Yes, the accessibility is what matters to us here now. Having access to that education and going through that, the law says that the child must have access, which means that if JAMB goes outside this way to say no, you can't enter school because of your age, that is going against that law.
All right.
Yeah.
But let me quickly just come in here, because we are trying to understand if JAMB can make internal policies.
Yes,
but there are other laws also that have educational restriction. I have not said even the Electoral Act has electoral restriction on the age. There's age restriction for contesting for position. So how come we have not gone to say that?
That is a constitutional issue.
Let me answer that. You see, in terms of education,
yes,
it is a right.
Inherent.
It's a right of the child to education. And you can't deny that the child simply because of age, so long as that child has met.
Yeah, but they have cited reasons that those children are not able to take care of themselves, and they constitute nuisance and drug abuse and all of that in the university.
The question is there an empirical evidence,
yes,
proving data that shows that some students in Nigerian tertiary institutions, because of the reason of their age, were not able to take care of themselves? Because for JAMB to come up with that policy, it must be based on empirical data that can be verified, proven to the whole world. Yeah. There's no such thing. They just come up with policy, and you know that policy is just made policy, and it cannot stand against the law. Once the law is there, policy must be set aside.
And I want to also say this, and let me just say this also, my dear brother,
yeah,
that where any policy of government is inconsistent with constitutional rights vested on an individual, that policy becomes null and void, yes, to the extent of its inconsistency. Yes. So the JAMB cannot claim that because he has power to make policy, yes, you will now design a policy that will be inconsistent, that will run against the provisions of the Constitution. Under Section 1, subsection 4 of our Constitution, which says any law that is inconsistent is null and void to the extent of that inconsistency. So that law or policy or whatever statement that JAMB is making is null and void. And then the other issue, still saying that they have to point in the portal that they are underage, but yet they are still beginning. It's still a restriction.
Yes.
It's still a restriction. All manner of restriction is not permitted under our constitution, because the fundamental right of these children is an inherent right, is an intrinsic right, is a right that they came into the world with. The right for them to be educated, and nobody can take it away by any policy, by any means.
So a child, even a child of 10 could apply to get into.
Obviously, if you can
the child of 10
can pass the exam,
through the,
if you can pass the exam,
pass the examination, why
if you can pass the exam, he's entitled to it on merit.
You don't have this outside here.
Of a child of about
Whiskey.
9 years,
Yes.
that already had his PhD.
Yes, 14 years, 16 years.
Outside the shores of this country.
So it has something to do with age.
Exceptional, brilliant children, and we are talking law, and the law we are talking about is that Section 2 of the Constitution says that any international treaty that Nigeria do his case becomes part of our
Yeah,
Of course.
and that the court confirmed in Abacha and Fawemi, and of course have the duty to apply them. And since the African Charter on the rights and welfare of the child has guaranteed the rights of the Nigerian child, the right to education, why wouldn't our court apply them? Since they are part of our law.
Even our Child's Right Act,
even the child,
stipulates that a Nigerian child must be educated. Whatever says to
And
education.
interestingly, Nigerian constitution had the same provision with the constitution of India before their 93rd amendment. And in their constitution before the amendment, the right to education and the socio-economic were not justiciable. Their court, the Supreme Court of India, creatively said no. The right to life now includes the right to nutrition, shelter, accommodation,
all the socio-economic
and the dignity of a human being. And even in Jan and India, the state of India, the Indian Supreme Court said that the right to education includes the right for the government to provide quality education and make it accessible to the children of India. No restrictions. So why will Nigeria still remain where they say except you are of social age you cannot enter university? Is that not hindering their rights to education, thereby deny them access to education, which the laws, our own laws now, have provided for?
All right, so those rights doesn't have limitation according to
No.
There's no limitation to right to education.
You see, the limitation.
The issue of limitation to right to education, there's none that I can think of currently, because the laws says that the rights of the child to education is not subject to any limitation.
Is a non-derogatory right. They are rights that you cannot assail. The right to education is a right that you cannot assail, because it's positive right and it's inherent, inalienable right of the person. So you cannot, unlike other rights where you talk about maybe environmental rights and all of those rights, those ones government can come in and regulate it, okay, or even specify the enjoyment, the manner of enjoyment of such rights. But where you are talking about right to life or right to education and all that, those rights are non-derogable.
All right, Barrister Michael Mana, when we say right is not there's no limitation, does it mean that even the universities that set cut-off marks for application into their university, the student can also question that in the court of law?
No. That is not the same thing as what we are talking about. When you take exam, you are expected to pass before you move to the next level of life. That is what it is. So the issue of saying that you have taken your examination, but you have not passed, you've not been able to get up to the enough marks to move you to the next level.
It's
not a right. It's not a breach of your own right to education. What you need to do is to get back to yourself, like the prodigal son did. He said he went back, he got into himself, and then sat down to think, and then look for a way to also do another examination and then get the required cut-off point. So it's not an issue of limitation.
But if that child is denied the opportunity of taking exam, that will also be a violation of his right.
Yes, and let's look at it this way. We have two candidates, candidate A and B. One age 18, the other age 15. The one that is age 15 wrote JAMB and got 360 in the UTME exams and cleared all his papers in WAEC in one sitting. Then, because of his age, he was not allowed to enter university. But the one that was age 18, that one was able to just get about 200 and then combined his WAEC papers and result to
NECO and all that.
and then was given admission. The other one was told to go home and wait until he attains 16 and above.
There is no other injustice worse than that.
What do you think will be the mental state, the psychological state of that child?
That child can even go into depression.
Yes.
For the 1 year that is going to waste at home, a lot of
For
things
no
can happen.
justification
He can be
whatsoever.
exposed to drugs and all manner of
Yes.
things, just because we don't want him to move according to the space of life.
Yes.
So it is very important to rescind that kind of decision by...
So what do you advise for those who have been affected by this policy, obviously?
Well,
Of course, there are decisions of the court now. Current
that back
decisions.
up,
but
yes.
if
So what we are saying is
there are
that
current
JAMB
decision
should...
of this in this respect and it's still in practice. So how do we reconcile? Is it that JAMB is
They should get another
disobeying,
from
Well,
court.
Of course.
Go to
After
court.
the decision in Radio and JAMB of December 30, 2024, JAMB now say, okay, we allow them, but recently they introduced this portal, their portal that they must.
Yeah, they are, and
still-
for if you are an
which is
exceptional,
still-
if you are an exceptional student, they are further, this
It
you
is-
must score. JAMB have put a
Yes.
policy that you must score above a certain, since you claim to be an
That is
exceptional student.
limitation, is
It
limitation.
is,
So
you
if
know,
you don't score, your result won't even be released in the first place.
the legal aphorism is res issa loquitur. That the first piece for it.
So that's what I'm saying.
If a
It's
child is exceptional brilliant, the result will show it. No, it doesn't need to click anywhere in the portal to say, I understand that I'm underage and but I want to apply, because that is still restriction.
So you advise that
Restriction is
this
any form
law
of
should not be
discrimination.
restricted, and what do you advise parents to do in order to get this law abrogated? Because there are still a lot of restrictions in the JAMB portal. If you claim to be an exceptional student, they expect you to score 300 and above, which they don't expect people who are of the age to score before your result can be
Now
released.
that is giving them higher qualification.
That is even
higher
error. That is
standard,
even wrong.
Which means the playing field
Yes.
is not
on that
even.
level.
Yes.
So there is discrimination because of age. This one is expected to get a higher mark than the other student. That's discrimination. That's unconstitutional.
So
It's still unconstitutional.
Yes, it's
to-
So, Barrister
yeah.
Michael, what do you advise parents? And
Yes,
students who have been
you see,
affected by
there
this?
is a decision of the court already on
Of
this
course,
issue.
the-
And you can just approach
Of
the
course,
court
the High
for
Court,
contempt.
perhaps they would have
Yes,
appealed it.
yes,
I don't
yes.
know.
You approach the court for contempt, start contempt proceedings against JAMB. And once you do that, JAMB will sit up.
That is if they have not appealed it because it's a High Court judgment.
It was, I think
Even
it
if
was
they
appealed
even if
to
they
the court
appeal,
of-
an appeal does
and it
not
was
operate
rejected.
as a stay.
Yes.
Until the appeal is determined. So an appeal does not operate as a
Yes,
stay.
as a stay.
Yes. And is it because these decisions are backed up by our law?
All right.